Most recently, we have enjoyed a great amount of success in collecting on medical accounts backed by employee-backed plans. These are plans governed by the ERISA law, which stands for the Employment Retirement Income Securities Act. This law is governed by the U.S. Department of Labor as well as the IRS. And collecting on plans related to this law is a very specialized field which requires a different type of collections activity and a more intelligent plan. Most recently, we have been working with national companies and hospitals and surgical centers to provide a tailored collection plan specifically targeting ERISA-backed plans for large companies such as ILWU, which is a large union. Well, first we educate patients on the laws and remedies that are already available to them under the ERISA Act. These remedies can include oversight by the Department of Labor and IRS, as well as legal remedies they have between themselves and their plan provider. What we did is analyze what it would take for the end result of the hospital's goal to occur, and that goal is to collect on the account. So we found it to be more efficient if we educated the patient on their legal remedies in order to get the patient to help the hospital collect on the account. Also, by informing the patient of their legal remedies, we are actually putting their plan provider, the U.S. Department of Labor, and the IRS on notice of possible violations, which in most cases helps motivate plans to actually fulfill their obligations because of possible legal exposure. While we're doing that, we also educate the patient on the contractual remedies they have between themselves and their plan provider, which in most cases leads them to an arbitration process which allows our clients to get paid. To begin our collections activity for employment-backed medical plans, we send out an informational packet to the patient which educates them about their remedies against their own provider, as well as the contractual remedies they have, specifically their remedy in requesting arbitration. We also provide them with all contact information for everyone they would have to contact in order to effect these remedies. We even go a step farther and send a copy of the informational packet, which is also a demand for the exact amount of monies their account is in arrears. We send that exact packet to the IRS as well as the U.S. Department of Labor. We send it on high quality paper, in high quality envelopes, and we send it priority mail, so that everyone that needs to know about our activities is put on legal notice. And inside that first contact, we give them 30 days to start making phone calls and effecting their remedies. Or we have to move forward with the plan. After we send out our demand letters, typically in 30 to 45 days, we start to see income come in from the accounts. At that point, we have a good understanding of which accounts will be paid without litigation and without further activities. After that, me and my staff analyze which accounts need to be moved forward into the litigation phase. We do this by having a paralegal contact every account outstanding and request information relating to whether or not the patient is using the information we have provided. If they are using the information we have provided and can give us proof thereof, we typically allow them the necessary time to effect the arbitration. If they are not using the information we have provided, we typically place their file into the litigation box. And from that area, we assess whether litigation would be an appropriate remedy to get the patient to again use the reference sheet and to use the documentation we provided. It is key to understand that even when we litigate a file, our goal is to always get the patient to use their contractual remedies with their insurance. And we only use litigation to help affect the ultimate goal of getting the account paid. Therefore, typically our litigation procedures don't end up in a trial. They often end up in a default judgment, and a high percentage of the time they end up in the patient utilizing the information we provided, utilizing their contractual remedies with their own plan, and the account gets paid. We have enjoyed an immense amount of success in that we spent 6 months devising this plan for a large hospital in Southern California. During this 6 months, I read through and analyzed all the remedies that a patient would have against their own carrier, utilizing the federal laws as well as the remedies provided through the contract that they have with their own carrier. So when we educate them about how to use these remedies, we typically enjoy a 50% recovery rate of expected contribution within 45 days. This has set a new industry standard and is considered cutting-edge collection activity. We have tailored our plan to be cost-effective in 2 ways. First, our plan is efficient. We are not litigating against the plan carrier itself. We are educating, informing, and enrolling the patient into helping us get the account paid. This makes the actual collection activities far more economical and thereby efficient. And we can then pass that efficiency on to the clients. And as such, we have a wide range of plans which can vary from a low amount paid by the client up front and a 15% charge on collected accounts to a complete contingency commission-based plan. It is up to the client and their needs. Some of the variables we gauge our plans on are how many patients the client wishes us to collect upon and the amount of the accounts in arrears. In order to begin our collection activities, we send out an email with about 5 documents which educate and inform our clients on what we are going to do and when we are going to do it. The documents and the process walk the client through a series of simple tasks aimed at providing us with a small amount of information that we will use to move forward with the collection activity. It is estimated the time it would take the client to comply with our information request is less than 2 hours. And when we get that information back into the office, we can start our collection activities within 3 to 5 days. And again, we've set the new industry standard in collecting 50% of the expected contribution within 45 days. So from one phone call, we can have the email package out to your business. You can fill it out within 2 hours. Typically it takes a day or two, considering people have other things to do and whatnot, but if the client wishes, it should not take more than 2 hours. Once we get that back, it will take us 3 to 5 days to process the information, and again, 45 days later, you can expect checks to be coming into your office. I would prefer if you called me personally or had one of your administrators or billing managers call me so I can explain the plan to you and perhaps tailor make a plan for your variables. And you can call me directly at 951-444-8971. That's 951-444-8971. And again, my name is Joshua Naggar, and I'm waiting for your phone call.